Good afternoon, Chairman Wayne and members of the Judiciary Committee. I'm Megan Hunt, M-E-G-A-N-H-U-N-T, and I'm here to introduce LB169. LB169 would prohibit employment discrimination based on sexual orientation and gender identity. This committee has seen this bill many times, most recently from me in 2021 with LB120, and from Senators Pansing Brooks, Moorfeld, Conrad, Chambers, and many other before them. And I actually made a note, because there's an interesting history of this bill. This bill was first introduced in 1994 by Senator Tim Hall, I believe. And so it's been tried longer than some of these testifiers in the room have been alive. And hopefully the 16th chime is the charm. Under Nebraska law, employers can legally discriminate against employees or prospective hires on the basis of their gender identity or sexual orientation. This means that LGBT Nebraskans can legally be denied job opportunities they're otherwise qualified for, endure harassment or retaliation, have their hours cut, be given less preferred position assignments, or even be fired based purely on who they are or who they love. A question I get with the Supreme Court Bostock versus Clayton County decision that found discrimination against LGBTQ people in employment to be unlawful is people ask, why is this bill necessary in Nebraska? And I can explain that to you for several reasons. After Bostock, the Nebraska Equal Opportunity Commission had to begin processing cases on the bases of sexual orientation and gender identity. I had extensive discussions with the commission over the past few years on this topic, and they informed me consistently that they would be able to more expediently complete their investigatory duties if we had this minimum standard in state law. Without clear coverage in state law, cases have to be taken federally, and when the state law doesn't at least mirror the federal baseline, it creates inconsistency. The Equal Opportunity Commission, said that smaller businesses that don't have legal counsel often don't understand their rights and responsibilities, and the NEOC ends up having to educate them. Getting this into state law would allow the NEOC to fully leverage all federal funds available to help protect Nebraskans from discrimination. They also indicated that clarity in state statute and the ability to leverage federal funds could also help them conduct education and outreach efforts for employers about what their rights and responsibilities are to protect themselves and avoid costly litigation. And that's from the NEOC. As it stands today, we have a patchwork of federal, state, and local laws that have different employment thresholds, which create uncertainty for employees and employers. Litigating in federal court is costly and time-consuming for all stakeholders. By passing LB169, we provide an avenue for recourse, a state or local court instead of a federal court that is more accessible and affordable for all parties. It costs nothing for employers to not discriminate against workers based on their identity or sexual orientation. If someone is doing a bad job, you can demote them or fire them. All companies would still have that right under this bill. Maybe the worker isn't a good fit for your business for some reason based on the behavior or their interactions with customers or something like that. Employers can still deal with that as they see fit. It's just that under LB169, no employer can give an employee less hours or fire them or refuse to consider them for a promotion purely because they're gay. Business leaders see this as essential to economic growth. The Omaha Chamber has told me their membership is considering this a priority this year and is willing to throw more support behind it than ever before as part of their recruitment and retention efforts. Representatives with the Omaha Chamber told me they'd heard about talent recruits not wanting to come here for fear of being unprotected. So this is not just some abstract fear, it's really happening. Polling shows that 75% of Nebraskans support these protections, including 67% of those in small towns and 82% in medium and large cities. The fact that Nebraska's laws don't reflect the beliefs of our state citizens makes us look closed-minded and aggressive. I conducted an informal survey on social media about this issue, to which hundreds of Nebraskans responded. One of the key takeaways of that survey was that young people don't want to live in a place where the culture doesn't reflect their values. Workers are hesitant to stay or come to a state that doesn't offer protections and security to their positions. Creating a home in a community that doesn't legally support you is very difficult. We're competing with our neighboring states for top talent, and we cannot afford to be a state that tells young people they are not welcome here. This bill also has an amendment, AM10, and that was filed in January, so it's been viewable to the public for quite a while. The green copy of LB169, the original bill, and the bills of others before this bill have only applied to employers with 15 or more employees. The reason for this is that our Nebraska employment laws on the rights of employers and employees are for the most part contained within the Nebraska Fair Employment Practice Act, which only applies to employers of 15 employees or more. With this amendment, AM10, which is already filed on the bill, I decided it's worth the body considering a measure that would apply these protections to employers of all sizes. This is done by creating two classes of employers and defining them, Class 1 employers and Class 2 employers, for those with more or less than 15 employees. The gender identity and sexual orientation anti-discrimination provisions are applied to both classes of employers while exempting the smaller employers from other requirements of the Act. The Nebraska Fair Employment Practice Act contains many sections with various requirements for employers. I know that in past conversations about why that act should apply only to 15 or more employers, I've been told that the law was structured so to basically not over-regulate small businesses out of business. There are some administrative requirements in that act that arguably, I agree, are way more feasible for larger employers to implement. It would be way more difficult for a small employer with fewer than 15 employees to fulfill. For example, accommodations for pregnant women or people with disabilities can be harder for an employer of just a handful of employees to implement. As a small business owner, I do recognize that there are some things that larger companies can do with their HR departments that are easier than small businesses. Doesn't mean it's right or wrong. It means I totally agree that it's easier for big businesses to do some of these things. But the spirit of the amendment is that without picking apart the other requirements of the Fair Employment Practices Act that I don't think need to apply for smaller businesses for the purposes of this bill, we are only applying the anti-discrimination provisions to smaller businesses in LB169 because, you know, to not fire someone and discriminate against someone based on their race, national origin, or ability, or sexual orientation, or gender identity, or sex, it shouldn't matter. It's free. No one has to do that. Businesses of 15 employees or less can do that too. I will be here to close, and I'll listen to all the testimony. And with that, I'll turn it over to our testifiers, and I'm happy to take any questions.
Any questions from the committee? Seeing none, thank you for being here.
Everybody who came to testify, I didn't really know who to expect for this hearing, and I was so encouraged to see the variety of viewpoints, you know, from both sides, honestly. And this was a great hearing, I think. You know, from the first few testifiers who spoke, you can see that this is clearly a corporate handout bill that I've introduced. That's my goal here. Just kidding. This is just Senator Hunt working for big business as usual. But no, seriously, I mean, I think it really says something that leaders in our business community have come today. They've stayed for the whole hearing, and that this is a priority for people who are driving the economy of Nebraska, who are some of the biggest employers in our state. And it's just an idea whose time has come. To address some comments that some people made, I mean, nothing is going to stop people who want to discriminate from doing that. This law is not going to stop discrimination, and that's not the goal. I mean, in the gay community, you know, you cannot compare ever like the experience of being queer with any other intersections of oppression, like race or gender or something like that. But the goal can't be to like get rid of all discrimination. The goal is just to say, in Nebraska, these are the values that we have for the employees that we're going to be having in our state, and that's that. I think that it is a messaging problem for our state, honestly, that we don't have these protections in law. As you heard people testify from the business community, they've offered jobs to people who said, I have a husband and I'm a man, so this isn't really a place that I feel like I'll be welcomed. And in past years, if you ever want to go back and look at past testimony, we heard from numerous people in the Nebraska community who were fired because of their sexual orientation. It was made explicitly clear that that's what happened. And there are lots of statistics about this that have been gathered by the University of Nebraska at Omaha, the University of Nebraska at Lincoln. Different nonprofits have different data, and they're all pulling from different sources. But whether you want to say like what percentage of people are discriminated or just listen to the anecdotes that people are sharing, it's clearly important to a lot of people. And, you know, honestly, the idea that homophobia is the flip side of the opinion to being gay, and that both sides are valid or something like that, that's not right. And that's not what we're talking about here. People cannot change who they are. Somebody who is born this way and they know who they are and they have the courage to live in a state that conspires to oppress them in so many ways, having the courage to do that is not an opinion. It's not a view. And I think that we have to, in this body, stop characterizing being gay or being queer, whatever, as a view or an opinion. And then at the same time say, and it's just as valid as an opinion if you don't support it. You know, you wouldn't say that about a man and a woman. You wouldn't say that about a black person and a white person. And I think that we talk about intersections of marginalization, it's the same. You wouldn't say, you know, I support you or don't support you and it's all valid. It's not. It's not valid. So in conclusion, you know, the goal isn't really to stop discrimination. The goal is to show the rest of the country that in Nebraska, we do not have legalized discrimination. And me and 67,000 other Nebraskans who identify as LGBTQ+ would appreciate this bill finally having a fair chance on the floor. And I'd be happy to answer any questions.
Senator DeKay.
Thank you. Thank you, Senator Hunt. You said that there were people that were losing their jobs not based on performance.
Yes, that's right.
Okay.
One example is Ralph Kellogg, who lost his job several years ago, and he couldn't come to this hearing, but he's come to many, many hearings years going on. So I can get you a copy of his previous testimony, or he can come meet with any of you as well. But there's numerous examples like that.
Follow-up question. What actions are being taken based on discrimination or however, since it wasn't job performance related?
Well, in his case, there's no action that he could take since it was completely legal to discriminate against him in Nebraska. Under Bostock, which was not in place at the time, but what could happen now is somebody could bring a federal discrimination case that would have to play out in federal court. That is a lot more expensive and a lot more difficult than just having a local or state, you know, judiciary figure out the problem, which is what the EEOC was talking about, the NEOC, saying that they spend a lot of resources and a lot of time kind of helping people with these claims, and they do a lot of education around this stuff for small businesses, and it's really kind of a federal issue since we don't have a state law around this. So when I hear them say that, it makes me think it might actually be less expensive for Nebraska, you know, businesses and for the administrative burden of the NEOC to pass this law so that there isn't any ambiguity.
Thank you.
Any other questions from the committee?